Hello and welcome to this Ndtv exclusive with the UU Lalit, former Chief Justice of India. He joins us just days after retiring. He had a very short stint as Chief Justice, just 74 days, 2.5 months, but he managed to get quite a lot done. Thank you very much indeed, Justice Lalit, for talking to us.
Thank you.
Very kind of you. Before we get into all of your very brief but memorable legacy in detail, I just wanted to ask you, what was the toughest aspect? Because you've been a judge, of course, you were a lawyer before that, distinguished lawyer, became a judge, Chief Justice of India. What would you say was the single toughest thing about becoming Chief Justice of India?
Various parts. Number one, apart from your judicial work, one has to take care of administrative decisions. And at the level of administrative decisions are multifarious activities. Number one, listing. Number two, mentioning. Number three, bench composition. Number four, constitution benches. Number five, what kind of matters to be listed before constitution benches.
Right.
So for these facets of administrative decisions,
That's one of the toughest.
that was one of the toughest part.
Now, there was always this question of how much someone can get done in 74 days. But you came out all guns blazing. You actually said this, I think, at your farewell. You managed to dispose of 10,000 cases against a filing of about 8,700. Did you already have this in mind when you came in, that you would just turbocharge your innings?
See, weeks before I assumed office, I had called for the details as to how many 5-judge combination matters are pending, how many 3-judge combination matters are pending, and constitution benches of 7 and 9 judges. It was impossible to have 7 and 9 judges in this short tenure of 74 days, correct?
Right.
So therefore, I did not concentrate on 7 or 9 judges. I concentrated on 5 judges. The day I took over, we were 30 judges.
Right.
Since then, 2 judges have retired and the third one was me. So therefore,
Right.
today we are 27. So 30 judges, I just divided 5 by 5. So 6 combinations of constitution benches possible. So therefore, I devised the way that there will be 6 benches of 3-judge combination, 6 benches of 2-judge combination. So 18 plus 12, 30. So just pick up 1 combination from 3-judge and 1 combination from 2 and you have a constitution bench.
Right.
Secondly, there were about 55 death reference matters which are still pending. And the death reference matters in Supreme Court must come up before a bench of 3.
Right.
So therefore, if you have just 1 or 2 benches of 3 combinations, the judges get after a while, after about say 3 or 4 death sentence matters, it starts weighing on their mind.
Yeah.
So therefore, one must have combinations getting changed every now and then.
So that also you managed to do?
This also we managed.
Was this tough though, to push something like this through? Because
no, what I did was, the day I took over, took oath, same day I had a full court meeting with all the judges, told them what exactly I have in mind. Everybody supported wholeheartedly.
They were all on board?
Absolutely. And that is how we could manage everything.
Okay, this is actually called some called it the T20 approach.
Yes,
to
a certain extent, yes.
To a certain extent, you would say it was T20. But is this, in a way, the biggest challenge before the Supreme Court? That you have both a backlog of cases, but you also have a backlog of appointments, right? There's always a delay in getting judges appointed.
There are a number of reasons. For instance, when I was a judge, and Justice Deepak Mishra was the Chief Justice, our strength had reduced to the level of just 22. So we
against the sanctioned strength of 34, if I'm not mistaken.
That time it was 30. After Justice Gogoi became the Chief Justice, it was raised to 34.
34.
So as against 30, we were just about 22 judges. Number of reasons. Let us not get into those reasons.
No, why not get into some of those reasons? But
see, at times what happens is that some recommendations are made, perhaps there are certain objections from the government quarter, then they have to have certain deliberations, maybe some inquiries.
Yes.
And so in the process, perhaps I think there is a delay. Yes.
But this is a problem, is it not? Because, you know this. Just, in fact, 2 days ago, a Supreme Court bench has asked the centre to explain the delay in clearing of about a dozen names.
That's right.
even though 10 of which was, I mean, you would be aware because this happened during your time, 10 of which was sent back by the Supreme Court, which means that the government has no grounds to sit on it, but yet there's been no response.
See, one can't go into those questions. They may have valid reasons, but the entire process must have a dialogue at various levels. So therefore, after the collegium recommends the names, perhaps I think there must be a dialogue between the governmental agencies and the collegium. And sooner the better. Sooner you actually take care of these issues, the better. Because, for instance, see, today we are 27 as against sanction strength of 34. So 7 vacancies, which means 3.5 benches. 3.5 benches would mean that roughly they could take about every bench 60 matters on a Monday, Friday, 120 and 150 matters a week.
That much is getting backlogged.
That is what.
But the implication in the comments made by this bench, Justice Sanjay Kaul and Justice Abhay Uka, was keeping names on hold, I'm quoting from them, is a device to compel person to withdraw names. And needless to say that unless the bench is adorned by competent lawyers, the very concept of rule of law and justice suffers.
That may be, these are some of the comments if you consider 1 or 2 isolated incidents. Take for instance the name of a very illustrious name coming from Karnataka, whose name was recommended. And there was absolutely nothing which was heard from the governmental side for a while. The person concerned then lost interest in the matter and then withdrew his consent. So therefore, perhaps I think the bench was referring to cases like that.
Where actually the delay can become a deterrent.
The delay can put off a person and he may say that, sorry, I don't want to be part of this. Then it's possible, a given condition, perhaps an individual may take a particular view in the mind.
But this seems to suggest, Justice Lalit, that this is when the judges say it's a device, it's almost seeming to suggest that the government is using the delays to kind of decide who it prefers and who it doesn't.
I may not go to that extent.
It
is something which the bench has to find. If the bench comes out with a conclusion like this, then yes, certainly yes.
But are you seeing this yourself, that there are talented members of the legal fraternity, lawyers, etc., who are or who may hesitate in coming forward to become a judge because now they're seeing that it can go into this deep freeze?
As I told you, one name from Karnataka is an illustration for before us. So perhaps if somebody thinks on the same lines, one can't say that he is a part of an exception. There could be that thought which may be entertained by others as well.
But in your time as Chief Justice, was there ever, because you talked of the fact that there's a need for a dialogue with the government, with the law ministry, was there any such experience you had of any interface with them?
No, I haven't had any kind of interface so far as that dialogue issue is concerned because I had very little time. 2 recommendations which I made. Number 1, Justice Dipankar Datta as the judge of the Supreme Court. That was made around 26th of September, if I mistake not. So just about 4 or 6 weeks. So therefore, that much time you have to give to the government to consider. So therefore, I did not initiate anything because of paucity of time. But perhaps I think my successor will certainly look into that.
All of this is actually becoming very important, Justice Lalit, because as you know, that this is coming at a time when this entire question of judicial appointments is once again being opened up for debate. At the moment, we have what is known as the collegium system, which, as you know, is a group of senior judges who basically appoint other judges to the Supreme Court and the High Courts. Do you believe that this system it may have its weaknesses or frailties, but by and large, do you believe this is a this is a good system, that
there are 2 facets. Number 1, the legality or validity of that system has been pronounced upon by a bench of 5 judges. So therefore, one has to accept it that this is the norm, which is a well accepted norm. And that's an established norm with which we must go about. Correct. Number 2, actual working of the collegium. There are certain issues in MOP that at what juncture the recommendation made by the collegium, within how much time should it be looked into by the government, within how much time the dialogue must get initiated. There are certain areas which are still in grey shade, correct? There is nothing like black and white on that issue. But these are matters of convention, which will get sorted out.
But you believe that the system where essentially judges are appointing other judges should remain as it is?
See, that is something which is the law of the land. So therefore, I don't have any choice in the matter. Whatever is the law of the land, we must actually obey that and follow that and implement it.
Okay, because you've heard what the law minister has been saying. He's been saying a lot of things. He says that this entire system is opaque and not accountable.
That may be his personal view.
And that across the world, judges don't appoint judges. In India, they do.
He is right to a certain extent that ours is a very unique idea where the judges appoint their successors. Perhaps if you see the models of UK, US, Canada, perhaps I think that may not be the situation. But that's exactly the matter where the constitutional amendment came up for consideration before the court.
Right.
And a bench of 5 judges has ruled in that favor.
Right. This is what is called the NJSC or the National Judicial Appointments Commission, where it was the idea was to set up a panel which will have judges, government, independence, and that was struck down.
Once that is the established law, we have to go by that.
But what do you make of, I know you said that it's the individual view of the minister when he said the system is opaque and accountable. But do you think that's fair to call it opaque and, not accountable?
That's for him to decide. So therefore, it is his view. There are certain counter views also coming from various
I'm asking what's your view. Do you think it's an opaque and unaccountable system?
Not at all.
You don't think so?
It's a perfectly valid, correct and balanced way of doing things. Say for instance, the judges from the High Court. They are recommended by a collegium of 1+2 in High Court.
Right.
So those judges are well aware as to who are the advocates who are practicing before them. They are aware on the administrative side as to what is the performance, what kind of profile the lower judiciary personnel have. So therefore, they select from these two sources, the advocates as well as the lower judiciary judges. They make the recommendation. The recommendation comes here after screening at various levels. Number one, the state government. In case there are any inputs, so far as the profile of that gentleman or the lady is concerned, that input is something which is part of the dossier or the record before us.
Right.
The matter goes before the consultee judges. Whoever is a judge coming from that high court, his views are also solicited. His views are there. Then the views of IB and everything is there. So therefore, you have inputs coming from various quarters. It is after that that the collegium at the Supreme Court level looks into the matter.
So you think that this is a good, at the moment you say it's a
now,
fair system,
for instance,
it's not an opaque system.
When Justice Ramana was the Chief Justice, at that time the collegium was Justice Ramana, me and Justice Khanwilkar. We perhaps made recommendations and which fructified about 250 recommendations.
Right.
So out of the strength of 750 in the high courts in the country, 1/3 got appointed during that 15 months tenure that the collegium had.
Okay, so you're saying that contrary to some of these suggestions, it is not an opaque system, it's not an unaccountable system. You're saying that there is...
Certainly, yes. So therefore, a system where every viewpoint is considered, has given due weightage, and then the recommendations are made.
But from his side, it seems to suggest that they would want to have a greater say in appointing the judges. The government wants to get involved. But I'm asking you, that could be his view, but I'm asking you, is that a matter of concern? Is there a fear that the greater involvement of a government in appointing the judges will raise the question of judicial independence? Will that be a challenge to judicial independence?
See, as of now, we go by whatever is in place, which is the judgment in NJSC. Which has laid down the perimeter of what kind of, the power has to be exercised within what area. So therefore, that's the law for us, and we go strictly by that law.
No, that is the law. But I'm asking you, is there a worry in the mind of someone like you that the greater role of a government may raise questions over judicial independence?
See, these are of course views. Now, for instance, even before all these ideas of collegium got established in our jurisprudence or ethos, we were going by what is called the executive appointees. And all the judges who were appointed in those days were through the executive route. But we have had brilliant judges in the Supreme Court.
Even during that time?
Even during that time. So it is not as if that everything got compromised under that regime. So these are two different thoughts.
Okay.
Of course, the idea is to select the best of the persons, correct? Whichever way one looks at it.
Yes.
I look at it from the perspective, what is the established principle? So therefore, if the collegium is the established norm, we go by that.
But overall, because there is this constant question that comes up about judicial independence, how independent would you say is India's judiciary, especially higher judiciary? Supreme Court?
Very independent.
Very independent?
Very independent. Absolutely independent.
No pressures, no...
See, one can't say that perhaps an individual may come under some pressure. That's a different thing. But as a body, as a collective, as an organ, as a judicial organ, it's completely independent.
Have you, in your time as both a judge and Chief Justice of India, ever faced any pressure of any kind from the executive?
Never, not at all.
No formal or informal message, phone call?
Absolutely nothing.
Okay, because I'll tell you why. Though it's impossible from the outside for those of us to actually gauge independence or not. One can only go by the public actions of the judiciary. And one of the questions that has come up recently, especially with the Supreme Court, is that a number of cases, important cases, constitutional cases, which could be politically inconvenient to the government, whether it's Article 370, challenges to the striking down of Article 370, electoral bonds, Citizenship Amendment Act, demonetization. Court has been sitting on these for years. Now, in all fairness, you fast-tracked some of these and you pulled them out of cold storage. But some have been saying that this delay is not just procedural. One analyst said by refusing to decide, the Supreme Court effectively does decide in favor of the government. In effect, it takes the side of state power against citizens.
See, that again one has to see in the context. See, for instance, I had a very short tenure, 74 days, within which even before I took oath, the registry notified 25 matters to be listed before constitution benches.
Right.
And in that short tenure, I did list all those 25 matters before 6 constitution benches. So it was possible. We have had the effect of COVID-19 pandemic situation. So perhaps it is as a result of that COVID-19 pandemic situation where the lockdown and the after effects of that, perhaps the benches could not be formed by the then Chief Justices, correct?
You don't think that, as some are suggesting, that these delays are not just procedural, but these are actually, in a sense, done to favor the government?
I won't say that. It is, see, as a body, we deal with and decide all the matters which are listed before us.
Okay.
So therefore, what kind of combinations to be formed is the prerogative of the Chief Justice. When it came to me, I did try to do everything in that fashion, that 25 matters to be listed before constitution benches.
I'll tell you why, because again there's this question of important cases, as I said, which are politically inconvenient to the government are put on hold. But then cases where the government wants a speedy hearing, and you'd be aware of this, that when there was this hearing on Saturday convened to hear the case of G.N. Sai Baba, who was charged, in the Maoist case, he was granted bail by the High Court. The Maharashtra government challenges, and an unusual Saturday hearing was heard.
Why unusual?
Because many believe it's unprecedented for the Supreme Court to hear a matter on Saturday, especially when it comes to suspend an order of discharge and acquittal and keep people in jail. You don't think it's unusual at all?
I look at it this way. See, as a Chief Justice, because I formed that bench,
yes,
correct? So therefore, I must also explain in what circumstances the bench came to be formed and how.
Okay.
See, as Chief Justice, I had 2 occasions to form special benches. One, immediately, I think the second day that I took over, my first working day was 29th.
Right.
30th was the second day.
Right.
31st was Ganesh Chaturthi day. So there was this Ganesh Chaturthi program. The Karnataka government had allowed Ganesh Chaturthi Pandal to be erected at one of the Idgah Maidans. So there was a challenge. The matter came before a bench of Justice Hemant Gupta and Justice Sudhanshu Dhulia on 30th. There was a disagreement between them. So I was in a bench with Justice Ravindra Bhatt, And at 3:45, we were to sit along with Justice Dhulia in another 3-judge combination. So at 3:40 or so, two counsel, Kapil Sibal and Dushyant Dave, came and mentioned the matter, saying that there is a disagreement. I said, I am going to be in a combination of 3, so I can logically hear that, but there is Justice Dhulia part of that, who was part of the earlier bench, where there was a disagreement. So I said, give me 5 minutes, I'll rise. We rose, and I just got hold of the judges who were available in the courts
To form the
bench.
Okay.
4 of them came to my chamber. Justice Kaul, Justice Banerjee. Justice Kaul was sitting with Justice Oak. Banerjee was sitting with Justice Sundaresh.
Right.
Justice Kaul had some difficulty, so I formed a bench of 3 of them. At 5:30, the bench again took over. Correct?
Okay.
So these are the kind of situations where a Chief Justice has to form a bench as early as possible.
But why would the
Now,
necessity be in this case?
I'll
Yes.
again come to that. The matter was mentioned that day, Friday was the last working day of Justice Hemant Gupta.
Right.
So Hemant Gupta, the normal convention is that the retiring judge sits with the Chief Justice. So he was sitting with me. We rose at 1 o'clock. The matter, therefore, because the Chief Justice's court was not available, the matter got mentioned before Judge number 2, that is Justice Chandrachud.
Right.
It was around 3:40 or 3:45 that the matter was mentioned. The prayer was, of course, for stay. This I got to know after everything. And the request was made that let there be a bench on Saturday. The order records the submission that yes, this is the submission. So I was about to, because 4:30 is the normal farewell by the bar to the retiring judge. So I was about to leave for that. That's when the registry officials come to me and say that, sir, there is an order which has been passed which contemplates forming a bench on Saturday.
But Justice Chandrachud, from what I understand, had refused. He refused to say that.
But how do I know?
Okay.
How do I know at that point?
You weren't aware that he had
I
said
wasn't
that there
aware.
was no
I
need.
wasn't
What was the
aware
tearing hurry?
because the registry official simply came to me that there is a bench to be formed.
Okay.
So I said, very well, I'll be meeting all the judges now there at the farewell itself.
Okay.
So I leave for the farewell. The first judge that I wish to contact is Justice Chandrachud himself. I asked him, is there an order that you have passed? He said yes. I said, then the next question, will you be part of that bench? That special bench to be formed on Saturday. He had some commitments, so he said that in the major part of the day I am not free. There are 3 other judges who are standing there close by. Justice Rastogi, Justice
Shah?
B.R. Gawai,
Right.
and Justice Ravindra Bhatt. So I asked each one of them, will you be part of that special bench? Justice Rastogi again had some prior commitments. Justice Gawai had prior commitments, so therefore both of them refused. I asked Justice Ravindra Bhatt, that will you be there? He says, I have some judgment commitments, I need to finish them. So in case you don't get anybody, then I am certainly willing, as a default arrangement. So I turned to other judges who were standing close by. One of them is Justice Suryakant. I asked him. He again says no, he has some commitments. Next to him was standing Justice Bela Trivedi. So I asked Justice Bela Trivedi. She says yes.
Okay.
So she said yes. Then the next man that I bump into is Justice M.R. Shah.
Okay.
So I asked him. He said yes.
So that's how the two of them
That is
came
how
to-
2 of them got together to form a bench. Neither of us, neither Justice M.R. Shah, nor Justice Bela Trivedi, nor me are aware as to what exactly had happened in the court.
No, but when you met Justice Chandrachud, he didn't mention the fact that he had actually said no to a speedy trial, because he said, what's the hurry, it can be heard.
No, he didn't say that. In fact, I asked him,
Yes.
will you be part of the bench on Saturday? He said he has certain commitments.
I see. But were you aware of what the matter was? What was the issue that was being sought?
See, the paper book doesn't come to the Chief Justice.
Okay.
Only the order came before me.
So you weren't aware that this had to do with Mr. Sai Baba?
Order after name, so and so versus Sai Baba.
Yeah.
Correct, yes. But what was the context, what kind of matter, what kind of prayer, So this is how the bench got formed on a Saturday. And I don't think anything unusual in that because two things. As a Chief Justice, my job is to make the bench available if the occasion demands that.
Yes.
In the first case, the occasion demanded. Why? Because the next day was Ganesh Chaturthi. I couldn't have listed the matter next day.
Sure.
Therefore, it had to be done at 5 o'clock that day itself. Similarly here, if the order had actually recorded the submission that if the urgency is there, then Saturday can be convened. So therefore, the order said that, therefore I convened the bench. What happens before the bench is a completely different issue.
I see. Okay, this is interesting because at times some of this criticism, right, that judges or the Supreme Court is acting in a motivated way or is serving the interest of the political executive can be unfair as well.
Absolutely unfair. These are 4 or 5 judges, and all these conversations happened perhaps in the earshot of all the office bearers of Supreme Court Bar Association
they were all
as well. So we were just standing together. As I entered the hall, the first person that I wanted to meet was Justice Chandrachud.
Okay, I ask this because even at the time when I talk about criticism that can be unfair, at the time even when you were appointed, you would have come across this, right? There were some questions about whether, because you had appeared for Amit Shah in the encounter case when you're a lawyer, that is this being done as a kind of a reward for that?
Not at all. See, for instance, I think the government changed sometime in May.
2014.
May 16th or something. I was asked for the first time in first week of April. So April initially sounded.
This is before there's a regime change.
Before the government took over. When the earlier regime was still in place, I was sounded through a emissary which was sent by Justice Lodha. That was my senior himself, Justice Mr. Sorabji. So he asked me on behalf of
Soli Sorabji was the intermediary.
So therefore he asked me whether will I be willing. I said yes. Then they wanted some kind of documents, that is to say your income tax returns, your bar association enrollment, and so on and so forth, which I furnished sometime in last week of April.
Right.
On 8th of May, I had a sitting with Justice Lodha when he formally made an invitation, gave me an invitation to be part of the bench. 16th of May is the government changeover. Correct? So therefore, the process had begun well
before the change of regime.
Before that. So secondly, it is true that I had appeared for Amit Shah, but very inconsequential appearance.
Okay.
His main counsel was always Ram Jethmalani. What happens is, if a counsel is not available on a particular day and the matter is going to get adjourned, then people don't brief the lead counsel. So in that capacity, I was briefed in the matter, I did appear, but it was a very inconsequential hearing. I used to appear for his co-accused.
Okay. In the same cases.
Not in Sohrabuddin murder matter.
Right.
There were two trials which were going on simultaneously. One was, of course, Sohrabuddin murder. Then the other was that while investigating into Sohrabuddin murder, there was some pressure which was getting employed on certain witnesses.
Right.
So therefore, there was a separate FIR. In that FIR, I was appearing for the accused who were supposed to be the persons who were wielding pressure.
So this was not, in a sense, as you said, the main Amit Shah matter. This was much more of an inconsequential thing. Because subsequently, even if you look at some of the orders you gave when you were in the position of Chief Justice, whether it's the Siddiq Kapan case, whether it's the Teesta Sarwar case.
See, again
these are, this is when it comes to matters of personal liberty. You ruled in the favor of release.
Again, that's a misconception that a judge has to decide in particular way. A judge decides the matter on the facts and law which is presented before him.
Right.
And that's why I say it is independent judiciary.
That's why you continue to maintain that it's independent judiciary. What would you say, though, was the most challenging verdict for you in the time when you were Chief Justice? Because if you look at what happened in the economically weaker section case, you were amongst the two dissenting voices. And many believe this is unusual for a Chief Justice to be part of a dissenting judgment. So was that a challenging moment for you?
See, to the best of my recollection, Justice Kher was in a minority in triple talaq.
Right.
Justice Kher and Justice Nazir.
Yes.
All three of us, that is Justice Nariman, me and Justice Kurian Joseph, were forming the majority. Today the circle has changed and now I am in minority along with a brother judge of mine.
Right.
That's true. This is unusual, but it happens.
So you would believe that it's unfair to exclude SC, ST, OBC communities from a quota that's ostensibly from the poor. That goes against the grain of...
That is our view. That is our view. Because, and I'm not trying to justify that, I'm just only trying to put the facts in the correct perspective as we found. According to us, if you see the record, there are poor, of course, yes, who are economically weaker. But who are the largest group forming that, who are part of that economically weaker section?
Right.
The largest group is actually those persons who are traditionally, what you say, coming from very disadvantaged classes of the community.
Right.
So therefore, for them, it is cultural disadvantage, disadvantage so far as upbringing is concerned, and also the reflection is on the economic front. Whereas people coming from the other strata of the society, for them there is no cultural
disadvantage
or disadvantage. It may be the economic condition of that family.
Right.
So therefore, as against three drawbacks, which are cultural, upbringing, and then secondly, lastly, the financial part. These people suffer only from one.
Yes.
And then to say that there should be a quota for them, you are trying to exclude somebody who are amongst the poor, the poorest of the lot.
Right.
So therefore, this is the theme of our judgment.
Okay, fair enough. Last question now, as you now finally, you've completed your innings. What are your thoughts of what you'd like to do after retirement? Because there's again a whole question mark of what Supreme Court judges or the higher judiciary should do.
I would love to do some law teaching.
Some law teaching.
At various levels, maybe the National Judicial Academy, go there as a resource person. Go to some of the law schools as visiting professor.
Okay.
So therefore, that's one area that I would be looking for.
But suppose the government was to offer you any position, would you accept it?
I won't say anything right now because there is nothing in the pipeline. But if there is an offer which is worthy of consideration, I'm not averse to that idea.
You're not averse. So what do you make then of the debate about whether there should be a certain Lakshman Rekha, that those who retire from the Judiciary Supreme Court should not be taking positions in the government?
Otherwise, take for instance now, there are appointments like NHRC chief. Or there is an appointment like, say, Lokpal. Or there is an appointment like Law Commission chief. Traditionally, these are occupied by persons who have retired from the Supreme Court. Of course, there have been High Court appointments also. Like for instance, Justice Ajit Shah was the chairperson of Law Commission. Today there is Justice Avasti who has been now appointed as just a chairperson of Law Commission. But normally, like say B.S. Chauhan, Jagannath Reddy, Jayachandra Reddy. So therefore, these are appointments.
So you do need
which are.
You need a pool of retired judges.
And secondly, if the Parliament thought it fit that a former judge or Chief Justice of the Supreme Court should be the rightful candidate. So do we say that the Parliament's wisdom...
Rajya Sabha.
Rajya Sabha is a completely different thing. Rajya Sabha is a completely different thing. What I mean to say is that places like, say, chairperson NHRC.
Oh, I see. That is, so this is all passed as by the Parliament.
Wherever there is a legislation which the Parliament has passed and the Parliament has prescribed that so-and-so person with requisite experience who was or is judge of the Supreme Court or former Chief Justice of Supreme Court.
That you
we
think
go by the wisdom of the Parliament.
But then you said something like an appointment to Rajya Sabha, which is what happened with the case. No, I'm not saying you said, but I'm saying when you said that's a different thing.
No, I didn't say that. It is for them to decide, those individuals. I wouldn't do that.
You wouldn't take the poll like as Justice Gogoi did, you would say no to that?
I won't do that, yes.
Why not? What would be your issue with that?
On a personal front, according to me, that's my personal view. Again, I'm not suggesting that those persons are in the wrong.
Okay.
But to my mind, having held the position as Chief Justice of the country, perhaps I think the position as a nominee member of Rajya Sabha is not the correct idea, or as a governor of a state is again not a correct idea.
Because it's what? It's a kind of breaching of a Lakshman Rekha? Or
No,
what?
not breaching of Lakshman Rekha. It doesn't mean that, according to me, it is going down the level in that sense. I won't call it demotion as such, but certainly not befitting the status of Chief Justice.
Right. But then that's the point about judicial independence, because when you said that the judiciary is independent, the allegation here is that these people were in a quote-unquote rewarded for passing judgments in favor of the executive.
I don't think
and
that
therefore
way.
Then you get this post-retirement
I don't think that
laddu.
way. These are all individual choices made by the persons concerned. Say, for instance, Justice K.S. Hegde. Correct. He was, after he demitted office as judge of the Supreme Court,
Right.
he contested election as Lok Sabha. So he was not a nominee. He contested elections. Through that elected representative role, he then became the Speaker of the Lok Sabha.
Right.
Correct.
So
These are all completely different dimensions to the entire
But
matter.
you said personally you would not
I won't
take
do
it
that.
because that's not something that is your cup of tea. But teaching is something that appeals to you.
Teaching, yes.
Teaching is something that, so let's see then, Justice Lalit,
yes.
what the new innings holds for you. But thank you very much indeed for doing this and taking a question.
Thank you.
Thanks
Thank you
very
so much. I enjoyed it as much as, as I think you must have enjoyed asking me questions.
Indeed. Thank you very much,
so
sir.
Thank you. Thank you.